One of the most confusing things in my mind about the Bill of Rights is who does it limit. A good example of this is the case that would be decided in 1833 called Barron versus Baltimore. And the issue here was the fact that the city of Baltimore, in its collective wisdom, was improving the streets in Fells Point. And the owner of a wharf discovered that every time it rained, his wharf was getting silted up more and more and more. The issue was whether or not the city owed him money for destroying his wharf. He lost in the state courts, and so being very inventive, what he did was to sue in federal court, and he argued that this was a taking without compensation and violated his Fifth Amendment rights. So it makes its way to the Supreme Court, and Justice Marshall says that you don't have a cause of action because the Bill of Rights says Congress shall make no law. It doesn't say that the states shall make no law. So the Barron versus Baltimore stands for the proposition that the Federal Bill of Rights only attaches against federal government action, and you cannot go against the states. The 14th Amendment, which is one of the Civil War amendments, was very important because what happens is that Congress is very upset with the states, the southern states, which were not recognizing the rights of our national citizens, meaning the former slaves. And so what happens is that they were trying to reimpose the condition of slavery on African Americans, and the Radical Republican Congress would have nothing of it. And so the 14th Amendment is very important because what it did was to say that no state shall. And so it protects liberty, due process, equal protection. And so the 14th Amendment that is debated in 1864, is ratified in 1868, is the bridge over which people who claim that the state violate their individual liberties can bring in the Federal Bill of Rights. The Bill of Rights ends with two very important amendments, the 9th and 10th Amendments, which are designed to protect rights that are not enumerated or to reserve to the states rights not given or powers not given to the national government. So what this is designed to do is to address what Hamilton feared in Federalist 84, that if you forget to enumerate rights, that they will be lost. So the 9th Amendment says that those not enumerated shall be retained by the people. The 10th Amendment, on the other hand, is trying to deal with the powers of the state. And the 10th Amendment says the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Now, what this concerns is those powers not given to the national government in Article 1, Section 8, or those powers not prohibited to the states in Article 1, Section 10, everything else is reserved to the states respectively. So, for instance, when Alexander Hamilton wanted to create a Bank of the United States in 1791, Thomas Jefferson, who opposed this, said that this violates Article 10 because it is not a power enumerated in the Constitution, and since it's not enumerated, it would be reserved to the states, and the states have the power to create banks. Hamilton argued that this was not an accurate understanding of the Constitution because of the necessary and proper clause. And according to him, the creation of a Bank of the United States was necessary and proper for the national government to carry out its functions. So notwithstanding the fact that Jefferson, the Secretary of State, and also the Attorney General at the time opposed that construction, George Washington accepted Hamilton's understanding and signed the bill creating the Bank of the United States. This is the first debate over the meaning of the 10th Amendment and the use of the so-called elastic clause, the necessary and proper clause of the Constitution, to enact those things not specifically enumerated in Article 1, Section 8.